Welcome back everyone. Today I'm going to review the last essay from the book on citizenship, which has been authored by four eminent personalities. So the name of the essay that has been written by Justice Gautam Patel is Past Imperfect, Future Tense. Now, Justice Gautam Patel is a judge of the Bombay High Court and a senior one at that. Now, recently he is also hearing a challenge to the IT rules which have been made, and these IT rules create some kind of rules for social media, and for example say information posted on the social media. And now let's come to his uh, essay. Now his essay is a simple essay. I am so happy that his essay is one essay that I've understood, but it failed to make many points. He made just one point, and that is that the court, when it hears the challenge, and he would say that the court should hear it sooner than later, but when it hears the challenge to CAA 2019, he says that the court should be mindful of the fact that it should not make a decision which should go down in the history as judicial infamy. He starts his essay with a very basic question, that is, what is the Constitution? He says that many people call it a document, but he says that it is a blueprint which envisions the end result and provides the method to achieve that result. Then he makes the same Gautam Bhatia argument, which is that all fundamental rights are not restricted to just citizens, and thus 14 and 21 are available to non-citizens, immigrants as well. And then he says that the fundamental rights chapter applies to chapter 2 of the Indian Constitution, that is that Article 11 argument, which is that the Constitution empowers the Parliament to make any law on fundamental or any law on citizenship, and that's why they can make any law. Does not mean that they would be allowed to abridge the fundamental rights of persons. And then he says that there is a deep relationship between citizenship and fundamental rights, and that he will try to analyze this relationship in his essay. And in his essay, he does not test the constitutionality of the CAA, because he says that it is a pending, it is already pending before the Supreme Court, and he is already a judge of the High Court. So, it is not even good for the judicial discipline for him to be commenting on that. He says that the Indian Constitution is a social document and not a political document. That means that there is an interplay between Part 2 and 3, which is the keystone of the Indian Constitution. Part 2 has 7 articles, which is that Article 6 and 7 deal with migrations from and to India. Article 8 is a deeming provision for certain Indian origin persons residing outside India, and Article 9 prohibits dual citizenship. The other 3 articles, 5, 10 and 11, are critical. 5 recognizes domicile, birth of parents or ordinary residence for the preceding 5 years as criteria for citizenship, and it says that such persons shall be citizens of India. Article 10 says that every person who is or is deemed to be a citizen shall continue to be a citizen, but this is subject to the provisions of any law that may be made by the Parliament. Then Article 11 tells us that nothing in the preceding articles limit parliamentary power to make any provision with respect to the acquisition and termination of citizenship and allied matters relating to citizenship. It is immediately obvious in the current context, he says, that why this trifecta assumes such signal importance. Citizenship is granted by the Constitution, but it is subject to control by parliamentary made law. Then he says that he frames a question, as most judges do. He says that can Parliament make a law that identifies one particular group, by religion in this case, but it could be anything else, and invoking the authority reserved to it in Article 10 and 11 deprive that one group identified only by a factor prohibited by Article 15 of citizenship, and therefore of all citizen-centric rights. There is therefore a real tension between citizenship under Part 2, coveted by parliamentary power, and citizen-specific rights under Part 3. If we work backwards from this, then it is constitutionally legitimate to effect a deprivation of citizen-centric rights in Part 3, especially those under Article 15 and 19. Now he traces them in 15 and 19, and these articles are only applicable to Indian citizens. Simply by stripping away the foundational construct of citizenship, this is the hard question of our times, and it is one that the Supreme Court must confront sooner than later. Now he says that the enjoyment of fundamental rights, most of the fundamental rights, lies in citizenship. Then he goes on to a very arduous journey of going through various courts of various cases that happened before them, became which became cases of judicial infamy for them, which are considered to be the worst decisions of the times taken by majorities, which have not withstood the test of the time. Now, in first case, he talks about some decisions of SCOTUS. Now, he talks about Dred Scott case, which is which was when the Supreme Court of the United States refused a petition for freedom from slavery, and Plessy versus Ferguson, the case that gave us the infamous separate but equal dictum when it refused to strike down a state law that said that people of color must use a separate rail car. In Plessy, as in the later case, there was a lone dissent. He says that in this later case is ADM Jabalpur, where Justice Khanna was the lone dissenter. Then he talks copiously about Korematsu versus United States decision. Now, Korematsu was a US citizen, but he was from Japanese descent. So there was this Second World War that was going on. The US had the government of the US had some skepticism that some of the people who were of the Japanese descent might be sympathetic toward Japanese cause in the war and might help the enemies. So what they did was that they sent a lot of these people from the Japanese descent to camps, to concentration camps, where there were a lot of people who were being kept. Now, what was happening was that in early 1942, the US government not only required all persons of Japanese ancestry to stay indoors, the lockdown of the time, but limited to one class. In May of that year, there came an exclusion order demanding that these persons report to a civilian control center from where they were to be sent to an internment camp in the interior of the country, away from the nation's borders. The order extended to US citizens, even those born there, and Mr. Korematsu was also one of those persons. The entire foundation of this edict was no more than a suspicion that they might be sympathetic to Japanese. And US Supreme Court by majority upheld this law by 6-3. The US Supreme Court upheld the law by 6-3. Justice Hugo Black, for the majority, accepted that any law that curtails the civil rights of a single racial group are immediately suspect. But they may not be unconstitutional, he says. They are only required to be subjected to most rigid scrutiny. And then he went on to say that while pressing public necessity may sometimes justify the existence of such restrictions, racial antagonism never can. In other words, these restrictions in normal times would fail any test of constitutionality, but because the war was going on, so it was fair and constitutional. Then he says, hardships are part of the war, and war is an aggression of hardships. Then there were three dissents by Justice Owen Roberts, Justice Frank Murphy, and Justice Robert Jackson. Justice Jackson described the action as a straightforward case for convicting a citizen as a punishment for not submitting to imprisonment in a concentration camp based on his ancestry and solely because of his ancestry, without evidence or inquiry concerning his loyalty and good disposition towards the United States. Then Justice Murphy wrote, I dissent, therefore, from this legalization of racism. Racial discrimination in any form and in any degree has no justifiable part whatever in our democratic way of life. It is unattractive in any setting, but it is utterly revolting among a free people who have embraced the principles set forth in the Constitution of the United States. All residents of this nation are kin in some way by blood or culture to a foreign land. Yet they are primarily and necessarily a part of new and distinct civilization of the United States. During the same period of the Second World War, there was a case in the UK Supreme Court as well. It was House of Lords at that time. Today, the UK Supreme Court, UK has a Supreme Court. At that time, the House of Lords was the Supreme Court of the UK. The name of the case is Liversidge versus Anderson. There was a declared emergency in operation. Special regulations of 1939 allowed the Home Secretary to intern, that is to say, to hold in jail without trial or court redress anyone if the Home Secretary had reasonable cause to believe that he had hostile associations, not very different from the Korematsu suspicion standard. Now, Home Secretary Sir John Anderson invoked these powers against one Jack Paldwigs alias Robert Liversidge. Now, he was jailed. Anderson gave no reason for his executive decision. Now, the House of Lords, which sat in final appeal, was tasked with deciding whether court could evaluate the executive decision objectively. In law, this means deciding whether a decision is reasonable, and that means asking if it is a decision a reasonable man might or plausibly could have taken, or was the court, to be silent bystander, required to accept, given the extraordinary circumstances, the entire subjective and unreasoned decision of an executive officer. What precisely did reasonable cause mean? The majority felt that the intention of the parliament had to be afforded supremacy. As you know, there is a parliamentary supremacy in the UK. But there was one lord, Lord James Richard Atkin, Lord Atkin, and he was the person who dissented, a lonely dissent. Now, there is this tradition in UK that the court speaks mostly in one voice. That is, there are 1, 2, 3 judges who are in the minority and they do not agree with the majority. Then it is usually discouraged that you don't write the dissent, because it would make the decision of the court seem a little weak, because then all the arguments of the other side would be in the dissent, and that would make sense to a lot of people who are sympathetic to that side. So there is this tradition that they usually tell there is this tradition that the minority judges do not write their dissents. And when this Lord Justice Atkin wrote this dissent, the Lord Chancellor, who is like the Chief Justice of that time, he requested Justice Lord Atkin that please don't file this dissent, because it is, first of all, it is very harshly worded and it is very stinging dissent. So, but Justice Atkin wrote it, and he also had some issues with some of his colleagues because of that. He wrote, in England, amidst the clash of arms, the laws are not silent. And this is one of the most legendary lines of all time, in which he says that amidst the clash of arms, the laws of the land are not silent. That means that you cannot do anything just by shouting war. That a war is going on, we will not be able to do this, we will not be able to ensure that the fundamental rights are upholded. He says that they may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty, for which one on recent authority we are fighting, that the judges are no respecters of persons and stand between the subject and any attempted encroachment on his liberty by the executive, alert to see that any coercive action is justified by law. Then Lord Justice Atkin, in a very way that would sting a lot of his colleagues, quoted from Alice in Wonderland, and here he says that I know of only one authority which would justify the suggested method of construction. When I use a word, Humpty Dumpty said, in rather a scornful tone, it means just what I choose it to mean, nothing more, nothing less. The question is, said Alice, whether you can make words mean so many different things. After all this long discussion, the question is whether the man, if the man has, can mean. If a man thinks he has, I have an opinion, he cannot, and the case should be decided accordingly. In other words, there have to be an objective test of reasonableness. That is, that if the Home Secretary of the UK government felt that this person may have some anti-national motives, then there has to be a reasonable test, which has to be to which the decision of the Home Secretary has to be put. Now, it cannot be merely because he felt so, not that it was based on any evidence or any test of reasonableness. Then he um, talks about the story of Korematsu War during the Indo-China War. Then of Korematsu during the Indo-China War in 1962. It is about the Deolewalas, the true story of the 1962 Chinese-Indian internment, in which in 1962 3,000 Indian of Chinese origin or descent were interned in an abandoned World War II prisoners of war camp in Deoli, Rajasthan. They were held there with no legal or constitutional remedy or recourse for half a decade, which is 5 years. Their crime was that they were Chinese looking and therefore the objects of unfounded government suspicion. Now, then he talks about that the nather of the Indian jurisprudence in all of this is ADM Jabalpur versus Shivkant Shukla, which is famously known as habeas corpus case. He says that it is perhaps the most pilloried Indian decision of all time. The majority held that the presidential order of emergency, which is invoked under Article 359, subclause 1 of the Indian Constitution, suspended all rights in Part 3, which is fundamental rights, including the right to personal liberty and the right to move a High Court under Article 226 for issue of a high prerogative writ remedy of habeas corpus. Consequently, the Supreme Court majority held that 9 High Court decisions to the contrary, 9 Indian High Courts had already held that the writ of habeas corpus cannot be suspended by a presidential order. But the Indian Supreme Court, by majority of 4-1, held that the order is constitutional and the writ of habeas corpus is suspended. Then he says that there was, again, just like Lord Atkin, there was just one lone dissenting voice of Justice Khanna. And he talks about one incident that happened in the court while the hearing was going on. Justice Khanna asked him, the Attorney General, Mr. Nirende, when Justice Khanna asked if the suggestion was that should a policeman shoot a citizen, that citizen would be without remedy. Day's response was, yes, he would. Day said, consistent with my position, my lord, not so long as the emergency lasts. It shocks my conscience, it may shock yours, but there is no remedy. Now there is this story which has been said, which has been talked about in other books, that is that Niren Day was not in favor of emergency. That's why he made an argument like this. The question that Justice Khanna had asked was, in complete sense, was this. He had asked that, for example, say there is a policeman. That policeman has an enmity with me. I am just a citizen. Alright? Now, if that policeman shoots me, what will be the remedy available to me? Now, that was a private matter, nothing related to law and order. Does that citizen or his family members have any remedy? Because that is a person who is agent of the state. Okay? Shot him. Now, what do that person do? Attorney General says, as long as emergency lasts, that person cannot do anything. And it is told in so many books that it actually shook up the bench, but still the bench ruled in favor of the government, in favor of the presidential order, and failed to uphold the fundamental rights. Then he talks about how this case, habeas corpus case, ADM Jabalpur versus Shivkant Shukla, has received 5 burials. First, there was 44th Amendment, which prohibited the suspension of Article 20 and 21 even during the emergency. Then second time, when the Supreme Court said this amendment had impliedly overruled the habeas corpus case. Thirdly, when Chief Justice of India, Justice Venkatachalaya, said the majority judgment belonged to the dustbin of judicial history. Then fourth, in a 2010 decision, two-judge bench of the Supreme Court in a habeas corpus said that the habeas corpus case was decided wrongly and that there was no doubt that the majority decision had violated the fundamental rights of a large number of people of the country. And fifth, in the Justice Putuswamy judgment, which is a privacy judgment, 9-judge bench judgment, which has expressly overruled this. In that judgment, Justice Sanjay Kishan Kaul, who is still on the bench, had agreed that the 1976 decision of ADM Jabalpur was an aberration in the constitutional jurisprudence of our country, and the majority opinion in ADM Jabalpur should be buried 10 fathoms deep with no chance of resurrection. But then he talks about the inconsistency that was seen in another Justice Putuswamy case, which was the Aadhaar case. Now, interestingly, you may be aware, you may not be aware, there was this case filed by Justice Puttaswamy. He was a retired High Court judge. He said that due to this Aadhaar scheme, my privacy is being infringed. So, what did the government do? The government came to the court and said that, my lords, this question is pending. What is that question? That question is whether privacy is a fundamental right or not. So before you decide this matter, that Aadhaar is violative of privacy or not, you have to decide this question, which will ultimately go to the 9-judge bench, that is privacy a fundamental right or not. So a 9-judge bench had to be constituted, and it was unanimously held that privacy is a fundamental right. But after holding that privacy is a fundamental right, in Justice Puttaswamy 2, which is Aadhaar judgment, it held that Aadhaar is not violative of any privacy. But here, Justice Chandrachud dissented, who was again a lone dissenter. He found the entire Aadhaar project illegal, invasive of privacy, and violative of liberty. He held that the creation of a surveillance state was unconstitutional. The issue is of global importance, and we have no dearth of example, from the deep surveillance conditions and face mapping technology in Chinese cities to the proliferation of security cameras in every corner of London. Then he talks, I'll be talking about everything that he talks about. He talks about 4 other laws that prevail in India. Sedition, he says that sedition was crafted and drafted and framed in a context that was by Britishers to salvage the voices of Indians. And he says, we so easily forget that we must most remember that our nation's independence too was fought for and won by acts that all constituted sedition. He talks about how UAPA bans most of the organization that it has banned is leftist organizations. He talks about how the 800-pound gorilla in the room is, of course, the CAA. In the context of this book, the dispute is in court, and it is most appropriate it is not appropriate to comment further on the amendment itself, but that the Act categorizes one particular community and reserves it for special treatment or for denial of benefits afforded to all others is stark. More fundamental is the question of proving one's citizenship, something that Part 2 of the Constitution does not seem to contemplate at all. It says that you can become citizen or there can be termination of citizenship, but under NRC, they are saying that you will have to prove that you are a citizen. Then he quotes from some journalists. He quotes from one of the columnists. That columnist has written that your passport, your voter identification, your ration card, your Aadhaar card, none of these are proofs of your citizenship. Then he quotes further also. But if none of these are proofs of your citizenship, then what will prove your citizenship? They are saying bring land records, bring this, bring that, your father's birth certificate, photo. Now, this is what Mr. Enram has also written in his essay. In his essay, he talks about how there are so many poor people in the country, and recently we are still experiencing floods. He talks about how there are people in Bihar whose villages are flooded every year, and everything that they have is lost. Now, do you expect them to keep land records of so many decades before and birth certificates of the father who may still not be, anymore? Now, how do we expect them to have so many old records to just prove that they are citizens of the country when they have everything? I think almost everyone in this country has a Aadhaar card today. Now, he's saying here that even your passport is not a proof of your citizenship, then what is? And then he says that the issue is grave, and it speaks directly to that most fundamental construct embedded in our constitution, the matter of being a citizen and having rights as a citizen. The challenge is before the Supreme Court, and it is not an easy one. So this is how he sees a relationship between citizenship and enjoyment of fundamental rights. And then in the end, he says, we look forward in trepidation, for we have faltered before, we cannot afford another misstep. At stake is something so vital, so fundamental, so taken for granted that we risk missing it altogether, the idea of India. Sooner or later, our courts, and we must face the most terrible judgment of all, the judgment of history. We should not be found wanting. So, in this way, he establishes this relationship between fundamental rights and citizenship, and says that the Indian courts have a very humongous task before itself, and they must not falter, and it is a very difficult task. Thank you very much for watching. I'll be back next Sunday with a new book review. Till then, take care, stay safe. Thank you.